Good morning, everybody. Very warm welcome to our peopleHUB event today. If you've not met me before, I am Victoria Brown. I chair this session. The clue is in the name, people. This is a people community. So if you're HR, health and safety professional, business owner, manager, anybody that has to manage people, then this is the community for you. So I'm delighted that you have joined us today. We will be recording the session, so if anybody is unable to make it, or colleagues, or feel free, we will send you out the recording so you can share this. Today we are going to be talking about the Employment Rights Bill, a significant piece of legislation that will shape the way in which we work in the future. So I am delighted to have Claire McGuinness with me. She is the Head of Operations at HPC. I actually attended a briefing session that she conducted last week, and I can tell you now, there's nothing she doesn't know about the proposed changes. She is the right person to be leading us through today's session. But before I hand over to Claire, just a couple of things before then. So we have we're going to have Mike first. So we are proudly sponsored by 1HR so that we can run these sessions complimentary to you. Mike is from the 1HR team, so I'm just going to hand over very quickly for Mike to just tell us a little bit about 1HR, and then we'll get into the Workers' Rights Bill.
Yeah, amazing. Thank you, Vic, and good morning, everyone. I'll keep it short and sweet, as I know Claire's got a lot to cover. So, as Vic mentioned, my name's Mike. I'm from the 1HR team, and we're the proud sponsor of today's peopleHUB event. 1HR is a all-in-one HR management software solution, which allows employers to basically oversee and manage all the employees within their business. And there's a variety of different ways in which they can do that using the system, such as dealing with sort of holiday and leave requests, absence tracking, running reports, keeping hold of crucial documents on the system as well, amongst many other things. So if you're interested in having a quick chat around the software, or even having a full demo of the system to see if it's the right solution for you and your business, my details are on the screen now, and I'll also put a little message into the chat at the end of the session. So hope you all enjoyed the sessions, and thank you very much.
Brilliant. Thank you very much, Mike. Thank you for joining us today. And final thing from me is just that if you've got questions, and I'm sure you've got lots of questions on this subject, I'd ask you can either do two things. If you're not using your phone, then please just scan the QR code like I'm doing now. You can then anonymously pop in what your question is, and then we will bring them up at the end of the session. You've also got the chat box as well. So we'll get all of those at the end. And if we've got enough time, we'll answer the questions at the end, or if not, we will certainly follow up with any of those questions. So please ask away. Right, I'm going to stop talking now. I'm going to hand us over to Claire. Claire, welcome to the session.
Thanks, Vic. Morning, everyone. And yeah, welcome. Thanks for joining us today. Just having a quick look, seeing there's a few familiar faces and names that are known clients, but for those of you I haven't met, yeah, thanks for taking the time today to join us. So yeah, we've got loads to get through within the next 45 minutes. So try and cover everything that we can so that you've got as much as possible to take away with you today. And obviously we'll have some Q&A time if possible. If not, then we'll do that as a takeaway as well. So I suppose just to get into it, we're going to be looking at obviously the Employment Rights Bill 2025. This is our agenda for today, for this morning's webinar. And what we're going to do first is just a brief overview from the last webinar I think we did back in March, when we talked about the new bill and what was likely to come out. So there's been some changes since then. So just going to touch on that so that kind of people are clear of what is definitely not going to happen at this moment in time from where we stand today, although there may still be some other tweaks and changes yet. I've just got some bits to run through with you what's not going to happen as well. But there's a lot of stuff still in the bill. Some of it's a little bit more trivial, and some of it is huge. I suppose, you know, big changes for particularly for SMEs, but we'll talk about some of those, the highlights of the trade union activities, as well as the big ticket stuff that everybody is, I suppose, keen to get more of an overview of what's going to happen. So we're going to have a look at the main headline reforms, what the key risks are for employers, and what that roadmap, what that actually looks like, of when it's coming and what's coming. So that you've got more of an idea of what you need to do to prepare and what we need to do to act on now, if anything, at this moment in time. Thanks, Mike. Okay, so a quick rundown of what happened with the bill. It was introduced back in Parliament back in October 2024, and it cleared both Commons and successive Lords readings, with the third reading in the House of Lords just last week on the 3rd of September. So then after that, it kind of enters into another phase of where the Commons and Lords go back and forth, ironing out their final details. And I think that's one of the last major hurdle before it gets royal assent. And to become royal assent, then obviously the bill needs to, that's when the King formally agrees to make the bill into an Act of Parliament. So then we have got the Employment Rights Act 2025. So a lot for us to kind of think about and get through, and then we have a little bit of a curveball with the recent resignation from Angela Rayner. So we know, we're expected that there may be some things that are likely to change or to be tweaked, or we may not get everything that we're expecting. But in all honesty, the truth at this moment in time, we don't actually know anything yet. As far as we do know is the bill that we've got at the moment is set to land and set to be set in place late October. But obviously, when we become more aware of what changes are likely, or if it is watered down, or if we don't get the full fat version, if you like, then we'll obviously be running another session on what those changes are. So yeah, we'll have the Employment Rights Act 1996, and then highly likely we'll have the Employment Rights Act 2025. So we'll have two ERAs. So yeah, just to note that when we are referring to particular case law with any client work or anything like that, we'll have to refer to what particular act it is rather than just the ERA. Something else for us to think about. This is what we need. Okay, so this is the stuff that's actually missing from the Employment Rights Bill at the moment. Several things that the government promised in its manifesto or in what was their Making Work pay paper that don't appear in this current bill. So I think the government committed to moving this to the next, in the future, at the next Parliament, the next election. So what's dropped off is the right to switch off. That's completely gone now. There's no statutory code for that, and there's no entitlement. It's not covered in this bill. I know that we'd had that on the previous webinar, that was something that was a front runner. So that's no longer. There is no longer a requirement for large employers to report their ethnicity and disability pay gaps. That's gone. And also there was the expectation of moving towards singular status of worker. So at the moment, as you know, we've got self-employed worker, employee and worker status. So the idea was looking at transition towards a simpler two-part framework of either employee or self-employed. So that's no more. So everything we're doing in terms of self-employed and employee and worker stays the same. There's no change on that for now. And then the fourth thing that's not in the bill are the reviews the government promised into the reviews of parental leave and carers leave systems. And that was really just to make sure that they were doing what they're supposed to be doing, such as how much leave parents and carers would get, what their eligibility rules were, and what the pay was during that leave. But that's not going ahead either. So don't know for sure, but potentially pushed into the next Parliament, say in 5 years' time if Labour are re-elected. But I guess we'll see. So if we just go on to the next slide, we'll have a look at what's in the bill. As I said, there's a lot to get through here. I've just put the main kind of big ticket stuff on there, but there is some other, as I said, slightly trivial stuff in as well, which we'll also touch on. And these are the main 12 that we're going to look at today. But what we're going to look at them is in terms of order of what that roadmap looks like. So we're going to look at day one, unfair dismissal rights. ending fire and rehire, or dismissal and re-engagement, whatever we're used to calling it, which I think that's a really important one. And then we've got the guaranteed hours, shift notice for 0 hours and agency workers. And to say that they're complex in the lease is an understatement. It's so complex. It's really difficult to get your head around it. And I think because it's still a little bit wishy-washy on that, we still haven't got full clarification of what that looks like in terms of payments and all that kind of stuff. But we can run through what we do know and what we have got up to now, which is pretty much looks to be set in stone. But again, not 100% certain that stay that way. And then we've got protection from third-party sexual harassment, some further changes in that. Flexible working, we'll touch on briefly. There's not a lot of difference in that, really. I think a majority of us have been operating as best practice, which is more or less the same as what this new bill is, but we'll touch on it anyway because it's obviously a big one for businesses and small businesses. So we'll have a look at that. We've then got an overview on the paternity, parental and bereavement leave, some small changes in there, but I suppose quite significant. And then we've got enhanced protection for pregnancy and new mothers. A little bit on that. Again, nothing's really finalised that we could take away as a concrete and say that's definitely happened. Still some tweaking around that. Statutory sick pay from day one, which I think a lot of us are familiar with, and that's more than likely to go ahead. And we've got gender pay gap and menopause, a little bit on that. Collective redundancy consultation. Again, quite significant if your business has got multiple businesses and what that looks like for you on how you how you should be collectively consulting. A look at what the Fair Work agency, what that operation looks like, and what, I suppose, what do we need to do in preparation for when that comes into play. And then we've got some, we'll touch on the trade union activity, which is one of the first ones that's coming up just on the next slide. But there's quite a lot of trade union movement in this bill. Whether it affects, predominantly SMEs who are maybe not unionised, or, maybe some of our schools and things like that, then yeah, they would be affected. So we've got an overview on that, but we won't go into too much detail on it. But those changes are first up really within once the bill passes. I think it's a couple of months after that, those union activities are expected to come straight into practice. Okay, thanks, Mike. So first on, and looking up at around about October 2025 changes, it's expected that the rules around minimum service levels for strikes will be removed. And right now in certain sectors, especially public services like hospitals and schools and transport, striking workers have to make sure that staff still work to keep essential services running. And that's what the minimum service levels are. But removing those rules means that unions don't have to guarantee that any workers will show up during a strike. So obviously it means the strike could be more disruptive because there's no legal obligation to maintain basic operations. And, employers can't enforce unions to provide a skeleton workforce. So I suppose if that applies to your business, it will have a significant impact on how your operations run. I'm trying to, in terms of schools and private schools, does it apply to private schools? Technically, yes, it does, but in practice, it doesn't, because the minimum service levels were never implemented for private schools anyway. So the repeal doesn't really change anything on the ground for private schools. But I suppose, plain HR language, it means strikes can now legally stop operations completely, even in critical sectors. But I think there's still a bit of political instability around that with the resignation of Angela Rayner. So less certainty about how firmly Labour will stick to this part of the bill, I think, again, remains to be seen. And then we've got dismissal for taking part in industrial action is expected to become automatically unfair. So what that means at the moment, if an employee is dismissed within the first 12 weeks, it's automatically unfair. So that 12-week limit acts as a cut-off, and after that, the protection against the dismissal is weaker. So the automatic unfair dismissal protection will apply regardless of the duration of the industrial action. So that 12-week limit will be removed. And yeah, as I say, that is likely to come into effect around about 2 months after the bill becomes law. Another one, I suppose, for those that are involved with trade unions. Right now, for most unions, the law requires a 50% turnout, plus a majority of those voting. And again, in some sectors like public services, there's extra rules for like 40% of all eligible members must vote in favour. And that's stricter than just more than half of those who vote. So the change in the bill is that unions will only need a simple majority of those who vote. So if more than half the people who actually vote to say yes, that's enough to authorise a strike, making it a lot easier for unions to get approval for industrial action. Right now, if a union votes for strike and they get that approval, the mandate only lasts for 6 months. After that, if the union wants to strike, it usually needs to hold a further vote, another vote. But under the new rules, the vote will be valid for 12 months. So unions can plan industrial action over a longer period without having to reballot the members. So that, again, can have a bit of a high impact. And in short, really what it means is that strikes can last longer. They can be easier to approve, and employers can't guarantee that nobody will show up. So if that's something that, you know, hopefully not, but if there is any industrial action on the cards, I think that's going to be a bit of a wild ride, to say the least. Thanks, Mike. And then coming up in April 2026, and saying April 26, it feels like ages away, but it's not, is it? It's just no sooner Christmas, and then before you know it, it's upon us, and we're looking at the usual national minimum wage changes and all of that. So next year we've got all of those usual stuff and all of these staggered bits that are coming into practice as well. So when we do the usual update in April for national minimum wage and all of that, it would be a good time for us to update, you know, support you with your policies on all of these changes as well at the same time. So that there's some things that you don't necessarily have to think about in terms of amending your policies. We can obviously support with that. But for the paternity leave and the unpaid parental leave, the paternity allows the partner to have 2 weeks leave, and under the new law, paternity leave and parental leave will be a day one right. And that's the only real change for paternity leave. So it's almost nothing, but the day one right would be the change for that. I suppose it will have some impact on employers, given that it's a day one right, particularly with regards to onboarding. You know, new hires requesting leave immediately, so planning to cover and workload allocations becomes a little bit more difficult or critical, depending on your business. And then we have got the restriction on taking paternity leave after shared parental leave is likely to be removed. Other than that, there's no changes on shared parental leave. One of the most complex areas for me is shared parental leave. Like, if that lands in my inbox, that is a hot potato, it's going to someone else. I don't understand it. It's more complicated than Choopy. And yeah, there's no changes around it. So there's nothing really significantly to worry about or have to change with that. Still just kind of sits where it is. Maybe a bit of a wasted opportunity for this bill to do something actually worthwhile with it, because I don't think a lot of people take it up. Probably because it's so complex and they don't understand how it works. So that's it for those for paternity leave and unpaid parental leave. And then we've got one that is, I suppose, that we're all more familiar with, the statutory sick pay. And that will be, when this bill becomes law, that will be paid from the first day of sickness. As you know, it's currently 3 days waiting and then payment from day 4. And then also the lower earnings thresholds will be removed. Don't know what that is necessarily yet. The Secretary of State will get the SSP, I think, as a percentage of pay. What's the impact of that likely for employers? A higher chance of short-term sickness affecting staff, and particularly in small teams. And with sick pay hit from day 1, more staff qualify. So I suppose your payroll is just more unpredictable on what that looks like. I think it'd be a really good time, even though that's coming in, not coming in until April 26. It's one of the ones that it's a good time to start setting the foundations. If you don't manage your absences as tightly as you think you should be, I think now is a good time to get those policies in place and what that looks like, so it's easy for you to plan, track and manage absences like you never have before, because it's going to be very different. I don't think there's anything else on that. And the only other thing to remember on that when managing the absence is the consistency of it. I know sometimes now as employers we kind of go, oh, we'll pay that one, we won't pay that one, and it's going to be the law, isn't it, from day one, so we don't get to pick and choose who we pay and who we don't pay. So yeah, tight, robust policies and consistency for that one. And then also in April 2026, expected changes. We've got collective redundancy and protective award. More so for larger redundancy exercises that would have, if we got it wrong, it could mean millions of potential liability if those consultation obligations are breached. So I think businesses are going to need to be more rigorous with the consultation, making sure we give proper notice, the 30 days, the 45 days, depending on what the numbers are, and making sure that we conduct meaningful consultations with employee representatives or unions, so that we don't get caught out and that 90 days goes to 180 days. So one to watch out for if you have got any planned or expected collective redundancy. And then we've got whistleblower protections for sexual harassment. So I think this is another bit of a minefield with the sexual harassment and the third-party sexual harassment. It comes up in this bill a few times with changes throughout 26 and 27. For this part, this bit of it is in relation to the whistleblower protections. So what it means really is right now employees can report certain wrongdoing, like illegal activity for health and safety breaches, and that would fall under the whistleblowing law and get protection from, I suppose, being punished or dismissed. And what it means is that sexual harassment will now count as one of those protected issues. So it means that if an employee reports sexual harassment at work, they can't be treated badly for it. It can't be demoted as exclusion or any other detriment because they reported it. And they can't be unfairly dismissed for making a report. So I think for employers, it's making sure that we take sexual harassment reports seriously, investigate them properly, and protect the person who's reporting it or legal or risk legal claims on it. And I suppose in short, it means sexual harassment reports are now formally whistleblowing. It gives extra legal protection to the reporter. So something, again, for us to add into our whistleblowing policies, sexual harassment policies, into our company handbooks, and obvious training for managers and senior leaders of what that looks like and how to handle them. Because I know from what we do here, the sexual harassment claims are pretty above average, and it doesn't mean to say that they're always just alleged or they're always just found that that's true, but the actual allegations and the claims being raised for whatever level that looks like, there's a lot of them. So if that now comes into the whistleblowing protection, it just means that we have to be extra careful on that we've got all of our processes in place and that we are managing them properly, and obviously protecting employees who do blow the whistle. And then we've got the gender pay gap and menopause action plans. Nothing really particularly for us to do at this point in time, but it's likely that that's going to come into to be voluntary from April 2026, and not expected to be mandatory till 2027. So I guess that is just creating some action plans around what that menopause and gender pay gaps look like, but nothing really specific to do at this moment in time. Just put it on there because it is going to be in one of the April changes to be voluntary. Thanks, Mike. Okay, and then we've got, again, coming up in April 2026, I think April, nobody's having a holiday in April there. We've got the Fair Work Agency, and this is a new government body expected to come up, as say, in April 2026, and its purpose is basically to make sure that workers actually get the rights that they're legally entitled to. And what it is, breaking it down, you know, it's bringing together existing enforcement bodies. So right now we've got a bunch of different organisations, haven't we, that enforce different workplace rights. Like we've got HMRC for underpaid holiday pay, Employment Tribunal, I suppose local councils in some cases. So the Fair Work Agency will combine all of those enforcement powers, if you like, into one agency, a little bit like a one-stop shop for checking whether workers' rights are actually being respected. And what that they will do is they'll actively make sure that employers are paying things like statutory holiday pay, statutory sick pay from day one. And from what I've researched about it, it will be a little bit more, I suppose, employee friendly, where now if you were to get somebody who hasn't been paid holiday pay, yes, they might, you know, they might phone HMRC and say, I haven't had my holiday pay. How seriously that's taken, or how much of an investigation is put into that, might be lower than what the Fair Work Agency will do. So I think really in practice, we should look at that as a little bit of a regulator for workers' rights, but maybe with a little bit more bite or with teeth, if you like. It won't just be an advisory, it can also penalise employers who break the rules. So if somebody says they haven't been paid holiday, or I've had my shift cancelled when the guaranteed hours come in, it will be a lot easier accessible for employees. So I suppose from a practical HR perspective, we're looking like payroll and holiday records need to be spot on. Sick pay calculations can't be sloppy. We can't be inconsistent with it. And that our policies and procedures are compliant with the new rules as well before 2026. And in terms of what those penalties look like, if you don't comply with the notice, then you may face a penalty of up to 200%, so twice the amount of what the underpayment was, and that would be capped at £20,000 per worker. And a little bit like all of my parking fines, if you pay it within 14 days, the penalty is reduced to 100%. But not something we want to be getting caught up in getting fined left, right, and centre for things that I suppose can be easily managed. So yeah, I think that will be some significant changes for small businesses if people are kind of I've got easy access to the Fair Work Agency, and depending on how they treat complaints, if you like, of non-payments or underpayments. So yeah, that'll be interesting. We go to the next slide. Thanks, Mike. And then from October, so a year down the line for us yet, we're going to be looking at the fire and rehire, or the dismissal and re-engagement. And I think this is a really important one. The Employment Rights Bill will make it automatically unfair to dismiss an employee if they refuse to vary the contract. So when you think of how many times employers change the contracts or vary them without realising that you can't actually do that it is, you know, you have to get agreement from an employee. You can't just change the certain elements of the contract without agreement. And I know that a lot of employers don't actually know that, and it's fine if we get agreement to do it, but for those that are enforcing it, it's going to have a real big impact. I mean, to give it a bit more detail, any dismissal will automatically become unfair. And remember, I suppose, at some point when we get the day one right of unfair dismissal, when that's in play as well, and we want to change terms and conditions, and if people don't agree to it, we dismiss and rehire. We're facing an unfair dismissal claim, as well as a breach of this fire and rehire new law that will be put into place. So there'll be no 2-year qualifying period, as well as that. So it's going to have to be something that I think we really need to consider on what that consultation looks like before we decide to unilaterally enforce any changes to contracts. And particularly if we're saying we're going to dismiss you on this contract and rehire you on new terms. So what it means really is there's one caveat to it, where the dismissal won't be automatically unfair, but the business owners and employers still have to show that it's reasonable. A limited exception where the employer is in dire financial straits and about to collapse, and then the fire and rehire exercise is essential. So that would be the only reason why, if you were to dismiss and rehire somebody, that would be the only reason why you would be able to, I suppose, justify doing that. And I think it's going to be a really difficult defence for employers to run. If you were to use my business was going to collapse, I think a tribunal would just take into account the extent of any consultation carried out and anything that's been offered to the employee to agree the variation. I think what we tend to do now, and what we advise a lot, is when owners are looking to change those terms and conditions because they're saying it's business critical. And our advice is always consult again until you can try and reach agreement. Look at what you can offer. And I think what that usually tends to be is some kind of a sweetener, if you like, some kind of an incentive to get agreement to reach agreement, so that the terms are changed and it suits both parties. But if your business is going with I was in dire straits, I was going to fold, I had no choice, you're not going to be in a position to necessarily offer any additional pay or incentive, really. So I think what it means you would have to demonstrate is that what your consultation process looked like, and I think that will be scrutinised. Otherwise, if you haven't got that, you've got no consultation, you just, we look at P&L and what happens with that. Whereas, yes, it's frowned upon. It always has been. It's always been, ACAS now say it's the last resort, but it's never been unlawful. And I think at this point now, it is really important because so many employers do it without realising it, or do it intentionally with realising it and think, oh, I'll run the risk on it, it'll be okay. Whereas now it will be unlawful. So I think, again, it's something trade unions who have long opposed against this practice, it's a big win for trade unions. Something for us to really have to look at what practices we've got in place when it comes to terminate contracts and re-engage them. And then we've got a protection from third-party harassment. So for some years now, employers have not been liable for third-party harassment. And that means it's when harassment on employees by people who aren't employees, such as customers, suppliers, service users. And from October 2024, that changed, in that the Equality and Human Rights Commission can intervene if employers fail to take reasonable steps to prevent third-party sexual harassment, other than sexual harassment. So that's changing. And the new Employment Rights Bill, Prevention Harassment by Third Parties on the Workforce, is that all reasonable steps, not just reasonable steps, need to be taken. What's a bit annoying is that we don't know what all reasonable steps are yet. I think the only thing that we can kind of go on the basis of that, it will be raised. So what we have to generally do now is have your policies in place, have your risk assessments in place, have your staff and your leadership team trained, and have a process in place of what an employee needs to do. That's going to be raised in terms of what all reasonable steps look like. So I think for that, it would be whatever you were doing before, do enough that's reasonable, and then have to do everything that's reasonably possible. So a wider scope, more proactive, less defensible, but to ignore those preventative measures, making sure that it's belt and braces really on that. So that's going to be that one. And then just to touch quickly, there's just recently we have had some engagement on the non-disclosure agreements. This will be avoid clauses that will prevent workers from alleging or disclosing work-related harassment or discrimination. So we can no longer tie that up in an NDA only in commercial aspects. So that's gone from non-disclosure agreements. For those businesses that use tipping policy, some changes for that, nothing major really. All employers need to do when this comes into practice is consult with the workers or representatives before creating a tipping policy. And you'll need to update your tipping policy every 3 years. So for those sectors such as hospitality, then yeah, you'd have to get input from your employees on what that policy looks like and renew it every 3 years. And then we've got employment tribunal time limits. Again, I feel like it's kind of a little bit under the radar, this one, which will have a significant impact. You know, at the moment, time limits for making a claim to an employment tribunal are expected to increase. They are 3 months at the moment, expected to increase to 6 months for all claims. So that tribunal clock's been extended and employees will have double the time limit. So without making it sound as though all of our SMEs count the days for when the 3 months is up, in some aspects, it will be a case of if there's genuine business reasons for example redundancies, we don't need to really worry about what that time period is. But at the same time, we have to be mindful that there is 6 months, double the amount of time that employees will have to make a claim. Whereas now we can say 3 months less 1 day, we know that we're kind of in the clear. Yeah, so double the time on that, just to, I suppose, bear in mind. And then there's going to be more changes in October 26 to the trade union rules. And that will be a new duty for employees to inform workers of their right to join a trade union. So what that means for us, regardless of whether we're involved with trade unions, whether we have any collective bargaining, all employers will now need to put that in writing. So that will need to go in contracts of employment, so that we're stating that they have the right to join the trade union, and that needs to go in the contract. So obviously we can support with that for any of our clients or any, you know, outside of that needs support with updating handbooks, contracts, written statements, whatever that looks like. But yeah, new legislation that will need to be in there. Thanks, Mike. Okay, and then 2027 changes. We've got unfair dismissal from day one. That right, the current law is employees usually need 2 years service to claim unfair dismissal. And we've got the general exceptions of whistleblowing or discrimination. So as we know, the unfair dismissal, it's a right from day one policy. And we've got, you know, discriminatory dismissals. An employee can't claim unfair dismissal until they've got 2 years. And that's what a lot of businesses operate on, aside from an internal probationary process. We've got those 2 years to kind of look and think, oh, it's safe. To be honest, a lot of employers now, the way things have changed, follow best practice. Some don't. Some think I've got 2 years, I can remove if it's not working out. You know, if it's detriment to the business, I've got those qualified 2 years to make that decision. A lot of where we've got mental health coming into the equation, where we would have to consider a disability or a protected characteristic outside of that anyway, where it would prevent employers from dismissing within under the 2 years anyway. So there's a lot of best practice already in place, and there's also a lot that's not. And rightly so, those 2 years are there for businesses to make decisions for the best interest for their own businesses and for their own teams and staff and all of that. But employees will have the right to claim it from day one, and that is as long as they've started work. So they won't be able to claim if it's a signed contract and it's withdrawn before the start date. I know now there's always arguments, isn't it? If you've had an offer letter, I've had a verbal offer, then you're employed. You don't have to physically be in the building. A contract is exchanged, so therefore you're employed. But the day one, right, you will have to have actually started work. And then there is to be a new consultation on a new statutory probationary period I think initially we all expected that to be 6 months, but the government are favouring a 9-month period. And the dismissal probation procedure that would allow to dismiss within probation as long as the business holds a meeting and gives the employee the right to respond or argue their case. So if somebody just hasn't turned in, we don't get to pick the phone up and say, oh, don't bother coming back in. Whereas, you might want to make a commercial decision and make that call and do that. And there would be, low risk or repercussions if there was no protected characteristics. But within that 9-month probationary period, that will be one of the big factors of that. The employees gets the opportunity to argue the case. And during that probationary period, employers will be, I suppose, permitted to dismiss employees more easily, provided the reason for dismissal is obviously related to conduct, capability, and it doesn't apply with redundancy. So the process for dismissal during this period is expected to be a bit more of what's being considered a lighter touch procedure. So that may involve, a meeting with employees to discuss performance concerns, but with streamlined processes. So is that if it was a conduct or capability, now that process might look like 3 meetings or 4 meetings, and follow that full process, where this could be a little bit diluted, so that it makes it a little bit easier within that 9-month probation period. And then we've got, I think a few things just on that. What we've got in the probation is we've already got probations ourselves. Majority of us do 3-month or 6-month probation. They're pretty standard ones. And with the statutory 9-month probation, I don't think it means we should remove them, because we've got an opportunity to manage that probation and demonstrate why it's not working out. So my advice would be to continue with the 3 months and 6-month probations, because that's your footnote of what that performance is like, and it's not a bad opportunity to get that, if you don't already do that, to start putting that in place, because that's what we're going to have to be able to demonstrate. And it will also, I suppose, increase engagement, because you're giving this employees who the same probationary review meetings and time and energy when they are successful. So it'll only increase engagement on that side of things. But yeah, I wouldn't look at it and say, oh, we don't need to have a probation period. It's the opposite. You would need to implement a more robust probation period, so we've got that paper trail. And then 2027 changes, we've got increased pregnancy and maternity rights. So pregnant employees and those returning from maternity leave will have stronger automatic or unfair dismissal protection. At the moment, there's protections against dismissal of employees on maternity leave or reasons related to pregnancy, but not much protection for new mothers. So the Employees' Rights Bill empowers, to establish regulations prohibiting dismissals for employees who are pregnant on maternity leave or during 6 months return to work period. And this protection is also extended to other forms, maybe bereavement leave, family leave, adoption leave, shared parental leave. Again, still a little bit of uncertainty around that, but that's expected around 2027. Same with bereavement leave. There's, currently we've got leave only for stillbirths after 24 weeks or for children under 18, but from 2027, employees and partners will also get 1 week unpaid leave for miscarriages before 24 weeks once the employment starts. So some changes in that. And then we've got the ending the exploitive 0-hour contracts. The new proposed laws on ending the 0 hours or exploitive 0-hour contracts are, as I said earlier, they're really complicated. And the new provisions they've replaced the Workers' Predictable Terms and Conditions Act 2023. So I think a lot of our SMEs use these 0-hour contracts and casual contracts, and some real confusion around what they look like and if they are on the correct contract and what I can do. How many hours do I have to give? What am I obligated to do? So in all honesty, by the time that comes around, it will need a whole training session just on its own. for what it looks like for us to get it right. But I suppose in short, the bill contains guaranteed hours provision. So if a worker is working under a 0-hour contract, then the employer is obliged to offer a guaranteed hours contract, and that will reflect the number of hours that the employee worked during the previous reference period. And when I'm trying to look at it, it's still a little bit more complicated, where it's referring to a specified day, but it's not clear what the specified day will be. So there's a little bit of uncertainty around the implementation of what that specified day is. But really, the guaranteed hours, it doesn't just apply to 0 hours or contracts, but also to minimum hours contracts, so which they will now be called. So they will guarantee a certain minimum number of hours that prevents rogue employers with replacing it with a 0-hour contract or a 1-hour contract. We won't be able to say, okay, you're no longer 0, so put you on for an hour, so that you can avoid the rule. But if the employer doesn't guarantee the hours, then the worker can bring a tribunal claim to cover any financial losses sustained as not being offered the guaranteed hours. But I expect that claim will be capped at a level, which again to be set, which we don't know what it is yet, but I imagine in a statutory way. So this bill also gives workers the right to reasonable notice of a shift. If the worker is on a 0 hours or works under a contract where shift patterns aren't known in advance, and the bill contains provisions for regulations that set out what is presumed to be reasonable notice of a shift, or insufficiently reasonable notice of a shift, but again, don't really have that detail yet. And then finally, on 0 hours workers, it gives the bill gives the right to a reasonable notice of cancellation or changes to a shift. And this prevents employers from booking someone onto a shift and then cancelling it last minute just before the shift's due to start and not paying them. And yeah, I guess we'll find out in due course what reasonable or unreasonable looks like. Compensation for the breach of that is unclear, and I think there's some real complicated provisions depending on length of notice to cancel the shift or a lack of notice to cancel the shift. So as I say, the more I think the closer to the time that is all to go ahead as it stands, we do, I don't know, a 2-day workshop. Thanks, Mike. Next slide. Just coming up to towards the end of now, I think. So yeah, we've touched on flexible working. At the moment, employees can request changes to their working arrangements up to twice a year, as we know. Employers have to deal with them in a reasonable manner and can reject for one of the 8 reasons. You know what they are, they're not meeting customer demands, etc. And that's what's in place at the moment. But the government said that it would change the law to make flexible working a default for all unless the employer can prove it's unreasonable. But it hasn't really done that. And the detail of this bill indicates that the employer is only really going to need to state the grounds of refusing the application and explain why you think that it's reasonable to refuse. So there isn't, example, an additional bit, cost. So there isn't really much change for that. Basically, employers just need to give a clear reason, which I think a majority are doing now in forms of best practice. But there's also no change on any penalty breaches. Certainly, no other demands, laws that people can demand a 4-day week or anything like that. It's pretty much as it is. Only employers need to make it clear for the reasons why they're rejecting it. And then we have the further harassment change. So the law will specify what those reasonable steps mean when preventing sexual harassment following the earlier changes in October 2026. Not entirely sure why it's changed from, it's implemented in 1 year with some changes and then to be staggered again in 2027 with a final, this is what all changes look like. But I've put it on there nonetheless because it is still an additional expected change. Same with the mandatory gender pay gap and menopause plans. Expected that those plans they'll become mandatory following the voluntary introduction in April 26. Collective redundancy, need to consider the total number of redundancies across the whole of the organisation and not just individual sites. So that will have a bit of an impact if you have got multiple sites and you think that, oh, it's only this one shop that we're going to close. Or I suppose years ago, you probably remember the Woolworths case when they closed all the shops and they did them as individual entities, if you like, whereas now that would be collective, which so would put them in a much worse position, if you like. So if there's more than 20 at each establishment, then we have to consult over 90 days. And within 90 days at one establishment, which means what it used to be is now reversed. It means we're deciding that there are 20 or more proposed redundancies, that all of those should be totted up. Separate establishments should be treated collectively. And then there is some regulations of umbrella companies. It's the umbrella companies to be brought into scope of the agency workers regime, and that will mean that they're subject to regulation enforcement, and I suppose under scrutiny by the likes of the employment agency standards. Workers engaged through umbrella models will have clearer rights and enforcement routes. So the implications for employers and the agencies is that I suppose there's a bit of a bigger compliance obligations when engaging with workers via umbrella companies. And that's that for that. And then finally, we've got just a couple of slides for you with what we've spoke about in terms of what the time frames of the roadmap looks like, for a quick review of that for you. So in autumn 2025, first off, we've got removing the minimum service levels for strikes, increased dismissal protection for industrial action, and lots of trade union activity. April 26, paternity leave and unpaid parental leave, sick pay from day one, collective redundancy protective award, whistleblowing protection for sexual harassment, gender pay gap and menopause action plan to be put in place, and the Fair Work Agency will be coming into play. So we'll be wrapping our heads around that from October through November, December, and then I expect onwards up until April 26. Looking at if and what other changes to this are made in that time, and if not, if it's if it is the act and that comes into to be law, then these are the proposed changes for 26 and 25. Next slide. More for 2026, what we spoke about for fire and rehire. I expect that will be no more unless your business is about to maybe liquidate or go into administration, and it's a last ditched attempt to save that. More harassment rules, the non-disclosure agreements, not having those harassment in there, tipping, and what those policy looks like, getting them in place for October. Employment tribunal time limits, as I say, has gone from 3 months to 6 months, and then again more changes to trade union rules. 2027 unfair dismissal from day one, right? The big one, if that stays as it is, which I think it potentially might, I think that's going to have the biggest impact on most businesses and particularly small businesses. But all of these other things tied in with it are all, sick pay from day one, everything from day one, parental leave from day one. There's a lot to take on, there's a lot to consider, there's a lot to get your payroll and your teams all ready for all of these changes. Bereavement leave, 0-hour contracts again, and what does that look like? What do we need to prepare in terms of how we use them? Mandatory gender pay gap and menopause action plans. If that applies to your business, then that would need to be put in place. Collective redundancy rules, regulation of umbrella companies. If that applies to you, then there will be more information, I think, at the time when that comes out. And then I think we've got a final slide. So yeah, just a brief recap really of what we should do. It's what do we need to do now and what do we need to do further down the line. I think now setting the foundations for what that potentially could look like, what our current processes are, and getting policies, training, all of those things in place. That's it. Thanks, Mike.
Thank you, Claire. Thank you very much for that. That was, you can breathe now and have a drink. What I'm going to do in terms of questions now, because I am obviously conscious of time, but I think it was really important that we went through everything today. I think next time, maybe in hindsight, probably we'll extend this session anyway to the hour. So any questions? There are obviously a few that are on the chat that we will follow up and share with everybody. The slides, we are going to put them into a guide for you so you can get and also share the recording. So I appreciate that this is really overwhelming. There's so many changes that we need to consider. And if you're not currently a member of the peopleHUB community, then please do apply to join. Mike, if you can just put the screen on for that. If we've got, yeah, here is, we will send you how you can, the link to do this. So we will help you for every step of the way along this journey that we're going to be on for a couple of years together, but I think we can do it together and understand where those changes are. And if there are any further changes, particularly with that cabinet reshuffle, we'll put on another session.